Good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. It's great to see everybody here this morning as we have a discussion about the basics of the Sunshine Act, one of my favorite topics, and it seems to be a favorite of a lot of other people too, given increased interest in the goings-on of state and local government. Let's talk about a couple preliminaries before we jump into the session. First, as you can see, this is primarily a PowerPoint presentation with me talking. The PowerPoint, if you're interested, it is available on the Office of Open Records website. You would scroll over to the training tab and you would be able to find all of the PowerPoints that we use for both our webinars and other trainings that we do. And you're welcome to use any of them. It may be just for your own future reference. Perhaps you have a friend or colleague who couldn't make it here this morning and you think it'd be helpful for them to look at it, or perhaps you're conducting your own local training. Feel free to use our resources to help yourselves out. Also, this session is being recorded, and typically what happens is it takes a couple days for the recording to be, we clean it up a little bit. Actually, the administrative staff cleans it up a little bit. They load it to the YouTube channel, and then a link is established with the web page. And you can find, again, you go over to the training tab, you can find all of the recent webinars that we've done on each topic. And same rules apply. Use it as you see fit. Training purposes, future reference, co-workers, friends who couldn't attend today. The recording will be posted in a couple days once everything gets set. Let's talk about questions, okay? Because obviously this is a live setting. If you have questions, type them in the chat feature, and I will do my best to answer them live as we're going through. But I have two conditions or two favors to ask you. First, we're talking about the Sunshine Act, so let's stay on topic. Second, and probably more importantly, is that try to keep your questions as succinct and brief as possible. And I realize that can be a challenge, but it's a challenge for me to sit here and read through sometimes several paragraphs of someone's comments while everyone else is patiently waiting. And usually in those instances, it's an unusually complex situation or something that's unique to a specific jurisdiction. And I usually do one of two things. I'll wait until the end of the presentation and come back to it and try and answer it for the good of the order for everybody who's able to hang on, or we'll take the conversation offline. On the screen right now is contact information for the office, the phone number that you can call into, the URL for the website where you'll find email accounts. And when you have an inquiry, first it comes into the administrative staff here, who are fairly well versed, better with the right to know law than the Sunshine Act, but that's changing. They're getting more and more questions with the Sunshine Act and getting better versed with it. If they can't answer your question, it'll get escalated up to one of the senior staff, and usually we're able to get back to you within 24 hours. A lot of times we figure if you're serious enough to reach out to the office, something's going on and it's probably time sensitive and we need to get back to you as quick as we can. We're usually pretty good about that, but I got to warn you, I was just talking to the Deputy Executive Director. Things are getting busier and busier here. They're breaking records with the volume of right to know appeals that they're dealing with, and they're trying to keep up, but it's a losing battle at this point. So we may not be able to get back to you as quickly as we would like to, but we'll do our best. Okay. I think that takes care of all the preliminaries, and let's go ahead and dive into the presentation. And first thing I want to talk about is, why is the Sunshine Act even important? And why didn't my screen advance? Let me get back here and see what's going on. Oh no. There we go. Okay, I'm not sure what happened there. But anyway, it actually comes down to what I believe is good government and government responsiveness. Now, here is some verbiage from the preamble of the Sunshine Act, or what I call the preamble. But let me just run through this quick. The right of the public to be present at all meetings of agencies, to witness deliberation, policy formulation, decision making, because it's vital to the enhancement and proper functioning of the democratic process. Furthermore, secrecy in public affairs undermines the faith of the public in government and public's effectiveness in fulfilling its role in a democratic society. Okay, believe it or not, that language is over, well, close to 80 years old, with the genesis of the Sunshine Act going back into the 1950s. And yeah, it's a very altruistic statement, but yet it's completely germane in today's society. I've had the honor and the pleasure of traveling to other countries where the idea of being able to sit in and sometimes stand up and comment and take your public officials to task is unheard of. Last year I was in Guatemala, and you're walking down the street and there's guys, all dressed in black carrying machine guns. You don't know whether they're the good guys or the bad guys. And the idea of being able to stand up in front of a public official, point your finger and say, I think you're wrong, I don't think they do that very much. So even in the United States, Pennsylvania is unique in having this open meetings law to the extent that it affords ordinary citizens, ordinary residents, the rights that it does. So it's a very important concept based on, our democratic constitution. And, I think Pennsylvania is at the forefront, and we need to ensure that our rights are maintained. So your interest here today is, something to be noted. Okay. When people call in or contact us about the Sunshine Act, and it's not unusual to get a phone call or an email saying, hey, I was at a meeting last night and they did this. Isn't that illegal? Or an agency will call and say, this is the situation we're facing, but this is what we're proposing to do. Do you believe that's consistent with the law? I like to think that the Sunshine Act, stripped down to its bare bones, is a three-legged stool. Yeah, I realize I'm mixing metaphors here in a major way, but the first leg of that stool is that we have a right to advance notice in how do we attend these public meetings. Okay, they need to tell us ahead of time. They can't just sneak in a meeting at the last minute. Then we have a right to observe the deliberations, meaning we have a right to sit and listen to our public officials as they discuss policy and issues that would lead to policy. And then, very importantly, we have a right to comment prior to any decisions being made. And when we use the word decisions, basically we're talking about votes that impact us, and whether it be at the state or local level. And there is an exception to the public comment, which I'll discuss. But, we take a look at these three factors. And if the agency, and when I use the term agency, I'm talking about, states, cabinet level agencies, boards, commissions. At the local level, you're talking about cities, boroughs, townships, authorities, school districts, and by an extension of school districts, it would be public charter schools. So, there are over 5,000 agencies in the Commonwealth of Pennsylvania, and the greater majority of which are subject to the Sunshine Act. Okay, so it's important that we take a look at, is the agency making a good faith effort to comply with the Sunshine Act? Occasionally there will be exceptions. You never know what kind of circumstances are coming around the corner that are throwing you, a wrench into the works here. And my opinion is that as long as the agencies are making a good faith effort to comply with the three legs of the stool, they'll be on firm footing. And like I said, there's always exceptions, but you do the best you can given the circumstances that you have. Okay, so let's move on. Yeah, now we're back on track. The first question that often comes up, is our agency covered? One of the things that I always recommend, especially during these webinars, is that when you're attempting to understand a law, don't forget to take a look at the definition section. Okay, a lot of times when you're looking at the language in the law, it can be, it can be legalistic, hard to understand. Sometimes it appears that there's conflicting provisions in there. And a lot of times, if you take a look at the definition section, with the Sunshine Act being no exception, it can shed some light. It can provide some clarity on exactly what the language means. So I would recommend doing that. And in looking at the language about whether an agency is covered or not, I think that helps, okay? So let's see what the law itself says. Okay, the Sunshine Act applies to any state or local government body and all committees. Notice I have committees italicized there because this is an important question. People will, usually there's little doubt as to whether the agency itself, the board made up of the elected officials, is covered by the Sunshine Act. But the question often comes up, okay, we've appointed a committee. Is that committee covered by the Sunshine Act? Okay, so then we come up to the next part of the definition, that perform an essential government function. Let me talk about that a little bit because that's somewhat of a subjective phrase. Let me use an example here. Let's say that our elected board within the jurisdiction, let me back up. The local girls softball team has won the state championship. Quite an accomplishment, and we want to have a celebration. So the board, the elected board, appoints an ad hoc committee. You guys organize this, okay? And we decide we're going to have a parade, get fire companies involved. We've got a township park, so we're all going to meet there and have a cookout with a presentation. And, we're going to recognize the efforts of the local girls softball team for what they've done. Okay, now, can you make an argument that that's an essential government function? Probably not. Okay, you're not going to find anything in law that says this is a role that government should do. And given the other responsibilities of what various government bodies are responsible for, the idea of making an argument that you should have a parade whenever the girls softball team wins the state championship, it just isn't going to hold water. Okay, so the chances are that any gatherings of the ad hoc committee would probably not be subject to the Sunshine Act because the result is not an essential government function. Now, if we were to change that up a little bit, let's say instead of a parade, that this is just a standing committee that annually meets to review all local ordinances to make sure that the language is up to date, that the ordinance is in fact needed, that it doesn't conflict with any other local, state, or federal statutes, and so forth. And then they report back to the board with recommendations on any changes that we should make to our list of local ordinances. Yeah, I think you could argue that that is an essential government function, that it is based on statute, and that any gatherings of that standing committee would in fact be subject to the Sunshine Act because it is an essential government function. Okay, then we come up to the next factor that exercises authority to take official action. Okay, this is also a somewhat subjective phrase until you take a look at the definition section within the Sunshine Act, where you'll find a definition of official action. And it goes into, somewhat detail. But one of the things that we need to take a look at is included in that definition is the term making recommendations. So if you have a committee appointed by the elected board that ultimately is tasked with coming back to that board with recommendations, that represents official action. And it would be subject to the provisions of the Sunshine Act. Okay, questions come up. What about a temporary committee that is tasked to provide a recommendation on closing, not closing a division of the agency? Well, it doesn't matter whether it's a temporary committee or not. Let me talk about the makeup of committees too, because there's somewhat of a misunderstanding that when it comes to a quorum, and that's the fact that people believe, or some people believe that if there is a committee, there needs to be a quorum of the elected board on that committee before it's subject to the Sunshine Act. That's not the case, okay? You can have a committee appointed by the board that has no board members on it, but if it meets the criteria that we're working through here, that committee would be subject to the Sunshine Act, okay? Even though there are no elected officials on that committee, all right? Common misunderstanding, but you know, let's clear it up right now. Okay, and Walt, good to see you again. Just reiterating your question in that the fact that it is a temporary committee has no bearing on whether or not it would be subject to the Sunshine Act or not. And closing a division of the agency, again, I think you would have to, it's always going to be, it depends, but I think you would have to look at its impact on the public and whether or not that rises to the level of a policy level decision. Okay, sometimes, you know, it depends, it can be semantic sometimes. What is a division, okay, within the agency? And, you know, is there statute that supports having that division? Is it a simple reorganization? Are we just changing the name of an organizational unit? I used to work in an agency where they used the term office, which was unique to state agencies. You just didn't find that term being used in state agencies, but yet there were procedures in place statewide that said if you did any organizational changes up to a certain level, you had to run them through for centralized approval with the governor's office. But because this agency used the term office, which was not part of the procedural, the procedures that were in place, they got around it somehow. It was interesting because it was purely semantics. Rather than using the term bureau, we're going to use the term office. So that gets us around this management directive that requires governor's office approval. Yeah, so, you know, case by case basis, but I think you've got to take a look at it and determine what is the impact of the decisions this committee is making, and is it in fact a recommendation? If it is a recommendation, then I would rely on the definition of official action within the Sunshine Act, and I would lean towards transparency by opening up the meetings of that ad hoc committee. Okay, so then we take a look at case law. Case law is interesting when it comes to the Sunshine Act because it adds, it kind of fills in the details. Now, historically, there has not been a lot of case law with the Sunshine Act. People just don't typically file suit against agencies when it comes to perceived violations. Although, we were just having this conversation this morning, that is changing. We are seeing more legal activity with the Sunshine Act in recent years. Just this year, you know, we've got some issues in the headlines where there are cases that filed at the county level that we are following here in the office to, number one, just because it's interesting. Number two, it's our job to stay on top of this kind of stuff. So here is some case law that sheds some light on the issue as to whether or not committees are covered. And this particular case, oh gosh, why am I drawing a blank on it? Yeah, it's Casey versus Ristown. is the citation. And it goes back to the administration of Governor Robert Casey several years ago. But the question was, is this committee appointed by the governor subject to the provisions of the Sunshine Act? Should they be required to open up their meetings? And the court came back. In this case, it was the Pennsylvania Commonwealth Court. And in the discussion of the decision, these are some questions that they said need to be answered when considering the issue at hand. First offhand, does the committee have decision-making authority? Now, you're going to say, well, why would you have a committee without decision-making authority? Sometimes committees are appointed just to gather information, okay? We don't have time, the elected board doesn't have time to go out and research the situation ourselves. So we're going to appoint, a panel of experts, quote unquote, to research this issue and then come back to us with just information. We'll make the decision, okay? We don't want your recommendation. We just want information that can be used to educate ourselves so that ultimately we will make the decision. Okay, so there's an example. And other times, and this happens more often than you would realize, you appoint a committee to a hot button issue that you just want to go away. All right, you kind of know what I'm talking about. It's like, we don't want to make a decision. We don't think we have to make a decision. And whatever we do is going to be wrong. So we're going to appoint a committee. We'll say, you guys go look at this. And by the way, don't come back. And hopefully by the time you guys are done, no one's going to be worried about this anymore. Or maybe someone else will make the decision for us. That kind of attitude. Sometimes it's just an effective way when you're dealing with a controversial issue so that you don't get caught in the middle. And it's surprising how many jurisdictions will employ this, okay? Then we come up to the next, and these points build upon each other. Are the members of the committee appointed by the board, and are they authorized to act on the board's behalf? Okay, again, you would think, well, why wouldn't they be? But yet there are committees in place across the Commonwealth that aren't necessarily appointed by the elected board in the long run. They are what I call self-appointing, where originally they may have been appointed by the board members. But now, I don't know, because of a lack of interest or lack of importance, the board, when it has a vacancy, the committee itself is responsible for going out and finding a volunteer to fill the vacancy, not the elected officials. So the board isn't appointing the committee members anymore because of it now being self-appointing. You're saying, well, how could that happen? Well, I'll give you an example. Public libraries. The governance of public libraries varies greatly across the Commonwealth. Now, they are starting to standardize more and more, but you will find public library boards that are self-appointing. So you could argue that given the nature, because they don't rise to meeting this condition, there's a very good chance that the gatherings of that public library board would not be subject to the Sunshine Act. Interestingly, many of them voluntarily comply, but that's another issue. They're not required to comply. Okay, so then we come up to what I believe is the most important aspect. This is the question that needs to be answered in the affirmative to determine whether or not the gatherings of a committee are subject to the Sunshine Act. Are the recommendations that this committee is making pursuant to statute, ordinance, or regulatory authority, where the ultimate result is the enactment of laws, policies, or regulations? Okay, let me break that down, use the term unpack, which is popular these days. Let's unpack this. If the recommendation of the committee going back to the elected board is based on statute, okay, remember the girls softball team example? You're not going to find a statute that says if the girls softball team wins the state championship, you have to have a parade. Okay, it just isn't there. But if there is a statute that you can relate back to the mission of the committee that says you must do this, okay, as part of the Borough Code, Township Code, the Authority Act, or whatever, the State Education Code, okay, if you can point to what that committee is doing and find a provision in law that covers that, then you can make the argument that the deliberations of this committee are covered by statute, thus going back to their recommendations to the elected board. Then, yeah, clearly, I would think that the deliberations of that committee are covered by the Sunshine Act, and they should open those gatherings to public scrutiny. Okay, now, I've gone through 2 slides worth of information here. Hopefully, I've provided some clarity, but if you're still confused, unsure about whether or not this committee should be subject to the Sunshine Act and open up to public scrutiny, my recommendation is lean towards transparency. Okay, and it's for 2 reasons. First, this is the Office of Public Records, of Open Records. We're responsible for transparency in state and local government. So of course we're going to say that. All right, it's our job to make sure that state and local government operates in a transparent way. But there is a more pragmatic reason, and it has to do with what I call the straight face test. Okay, sure, it's inconvenient to open up a meeting and follow all the provisions of the Sunshine Act. It would be a lot easier to just go over to the conference room, get everybody together and hash things out. Okay, but if you do that and someone finds out about it and then files a complaint, you could find yourself standing up in front of a judge explaining why you didn't open up your meeting to the public. And you have to do that with a straight face. And if the judge disagrees, things could go south real quick. Okay, so sometimes it's easier to deal with the inconvenience of having to open up your meeting to public scrutiny than it is to stand in front of a county judge and try to explain to them when they believe it's apparent you violated the law here, and do it with a straight face. Okay, if you think you can and you have justification for doing it, then more power to you. But I don't know how many of you have been in a county courtroom, and sometimes the judge is having a bad day. I would rather not do that. Okay, so my recommendation is lean towards transparency for a number of reasons. Okay, now we have to answer the question: is it a meeting? Okay, and again, you can find helpful information in the definition section. Okay, a gathering of public officials doesn't necessarily rise to the definition of a meeting. We'll get a phone call. Hey, I saw 3 of the township supervisors have a breakfast together down at the local restaurant the other morning. Isn't that illegal? Well, no, it's not. It depends what they're talking about, what they're doing. Okay, if all they're talking about is the weather, their kids, the girls' softball team, then that's not a meeting. But let's break this down a little bit. First question that needs to be answered: is there a quorum? Okay. Now, I mentioned about committees. Okay, you don't need a public official on the makeup of a committee when considering a quorum. Okay, it comes down to, is there a quorum of the committee members? Okay, but let's talk about the elected officials specifically here. If there's no quorum, then by code, they cannot conduct official business. So it's not a meeting. Okay. Then there's the question, well, what if we have enough, but someone needs to phone in? Okay, they're out of town on business, but they're going to phone in. Okay, it depends on the jurisdiction. Let me think here. First-class townships and boroughs must have a quorum physically present in order to conduct official business. Once that quorum is met, then anyone in addition can phone in and you're okay. Now, when they phone in, what we're talking about here, and it could be, a Skype call using Teams or Zoom, something like that. Okay, but the connection must be direct. Everyone must be able to hear the person phoning in, and the person phoning in must be able to hear everyone else. Meaning you can't have someone sitting there with a cell phone up to their ear relaying back and forth. Okay, you can't have an intermediary. Okay, now those are the two exceptions. For every other body that I'm aware of, you can have a quorum with an element or some of the members phoning in, okay, as long as at the end of the day, or, I should say at the beginning of the meeting, you have a quorum of the board, some who are physically present, some who are phoning in, okay, that is acceptable. Now the question has come up, well, what if everyone is phoning in? This has never been litigated, but I have testified at public hearings where it was clear to from the legislators that their expectation is that there is a physical meeting. Okay, you cannot have just a virtual meeting with everyone online. There is an expectation from the legislature that the public has the opportunity to be physically present at a physical meeting in order to comply with the intent of the Sunshine Act. Okay. Now that's what I've received. That's my take based on face-to-face comments with legislators. I do need to make it clear though, that number one, not everyone agrees with my conclusions, and that this has never been litigated. There is no case law to support what I'm telling you. Okay. Just, that's the fine print, if you will. So that kind of takes care of the whole question, is there a quorum? Now, we need to answer the question, is there deliberation? Okay, the definition of deliberation, again, which you will find in the Sunshine Act, is any discussion that could lead to a decision. Okay, not any discussion that leads to a decision, any discussion that could lead to a decision. Okay, so it's possible you get a discussion where there's no decision, but if that word could is in there, which kind of opens things up. So is there discussion that could lead to a decision? If in fact there is, that's a meeting, okay, and it should be open to the Sunshine Act. Okay, so then we come to the next question, is there decision making? Okay, discussion leading to a decision. What if there is a decision? And sometimes you have a decision without any discussion, which is a red flag in itself, but we're not going to go there this morning for lack of time. But a decision basically is a vote, okay? It's polling the members, having the majority rule, this is what we're going to do, okay? Typically, it needs to be in the form of an official vote as part of the record of that gathering, of that meeting. Okay, and then finally, I just want to say for the good of the order, beware of email meetings. When it comes to policy level decision making, it's not unusual, school boards or boroughs, townships, or whatever, a new board is seated at the beginning of the year. Perhaps the chairperson is from a business background. They're used to just taking care of business with an email, okay? Why do we need to meet when we can just, send an email out to everybody, get your thoughts on it, and make a decision? Unfortunately, or fortunately, depending on how you look at it, that would be in violation of the Sunshine Act for policy level decision making. It needs to occur in a public setting, in front of the public, so that they can see what's going on and that they can comment before those decisions are in fact made. Okay, now I've used the caveat of a public level decision, or I'm sorry, policy level decision. That is to differentiate from administrative level decisions. I'm going to use an example here, which may or may not help, but it's, I've used it for years, where the board has had a meeting, and at that meeting, they voted in a legal fashion to allot, let's say, $2 million for paving projects in the borough for the coming year. Okay. As part of the budget, we're allotting $2 million. That is the policy level decision. Okay. It's part of the budget. We voted in favor of it, all in front of the public. The public has had an opportunity to comment, et cetera, et cetera. The decision's been made, no problem. Now the question comes up, okay, what streets are we going to pave? Are we going to fix the potholes? And that now becomes an administrative level decision, which can be made outside of the public eye, because the big decision was made in front of the public. Okay, the policy decision was $2 million for paving. Deciding which streets to pave now is an administrative issue that, maybe the board wouldn't even deal with. Maybe they turn that over to the Public Works Department and just let them make that decision. But, maybe the board has decided we want to review it, so we're going to do it as part of our administrative responsibilities. They would not have to do that in front of the public. Now, again, I'm just using that as an example. Sometimes it's very subjective to delineate between what is policy, what is administrative. But, you do the best you can. You try to adhere to the Sunshine Act whenever possible. If it looks like you're pulling a fast one, someone will take you to court. Ultimately, the truth comes out. So you just want to be careful. And like I said, err towards transparency. But beware of email meetings as a matter of trying to conduct policy level and the decisions that result from that. Okay, what is not a meeting? Well, I just got done explaining administrative versus agency business. Work sessions, okay? School districts are, as a matter of practice, they conduct work sessions. Most of them do. They have their regular monthly business meeting, but then they also will have like a bi-weekly work session. A work session is a gathering of the board where it's primarily for information gathering. Typically, the board will meet and like the superintendent or the assistant superintendent or the assistant to the assistant super, oh, I shouldn't be going here. But, you get the idea where they will stand up and make presentations to the board about ongoing projects, about matters that the board should be educated on, should be made aware of, et cetera, et cetera. The members of the elected board can ask questions of the superintendent and have give and take, but the board members themselves cannot discuss the merits of the presentation amongst themselves, because that would be deliberation, and deliberation must occur in a public setting. Also, they cannot make decisions. They can't sit there amongst themselves and say, well, given what the superintendent has presented here, I think this is what we should do. What do you guys think? No, because number one, it's deliberation. Number two, the result of that deliberation would be a decision. And again, decisions must occur in a public setting. One of the things that we will occasionally get reports about is when the board meets for its decision, when the board meets for its business meeting, there will be a motion without any discussion, and the board just votes. That kind of tells you that there's a good chance discussion occurred somewhere else. Okay, that's deliberation. When did they deliberate? Where were they when they deliberated? Was the public present? Okay, all questions that need to be answered. And if there wasn't, if you suspect that it didn't occur in a public setting, we go back to that straight face test. Okay, and what's the judge going to say? All right, so you can have gatherings, like I said, it's just that you need to make sure there's no deliberation and there's no decision making. Otherwise, you've got a potential violation for the Sunshine Act. Okay, first leg of the stool, public notice. Let me get a sip of coffee here real quick. Okay, the Sunshine Act requires that in advance of the first regular meeting of the year, usually what we call the organizational meeting, For boroughs, townships, that's usually the first Tuesday of the calendar year. School districts, it's a little different. Authorities, it's all over the map. But for your annual organizational meeting, prior to that meeting, 72 hours, there needs to be a legal notice that appears in a paid newspaper of general circulation for that jurisdiction. Okay, now that notice would also list the dates for any further meetings, regular meetings that are scheduled for the calendar year. So if it's like the first Tuesday of the month, it would list those dates. If by chance there's some sort of conflict where we can't meet on the first Tuesday anymore, let's change it to the second Tuesday, then you need a second legal notice letting the public know that instead of the first Tuesday, we're going to meet on the second Tuesday, and you would list the corresponding dates. Paid newspaper of general circulation. Yeah, it's becoming harder and harder to find paid newspapers. But this is what the law says. And until the law is changed, we are compelled to follow the law. If it's become an issue for you, I would suggest you contact your state legislator and let them know how difficult this is becoming. You're saying, well, why can't we use our website? Well, you can, okay? You can use your website to advertise meetings, but you still have to comply with the language of the Sunshine Act, paid newspaper of general circulation. I would recommend using whatever social media presence you have to advertise your meetings as well, but it doesn't get you out of this requirement. Okay, and those free sales circulars that fill up our mailbox 3 times a week, they don't count because they're free, they're not paid. Okay, so legal notice. And then it also needs to be posted at the meeting site, the conference room, the meeting room, whatever it is. Just walking in the building here today, I saw a sunshine notice for one of the agencies posted on the doorway. Okay, their list of meetings actually was an annual meeting. So it was notice of the annual meeting that they're having posted here at the meeting site, which tells me it must be somewhere in this building that they're having the meeting. Okay, does it have to be posted in a location that can be accessed at any time or only during working hours? Hey, that's a great question. And I don't know, but I think if you do it during working hours, you would be okay. Yeah, because, some places, you have nice buildings, nice offices. You don't want to clutter things up with, notices posting in the windows or so forth. You do the best you can. And if it's posted, my experience, usually walking into a local government building, is that there is a bulletin board inside. That's where you'll find the posting of the sunshine notices. So I think, as a matter of practice, you'd be okay with that. I've never heard of any litigation saying that it needs to be posted outside. So I think you'd be okay there. Yeah, good question. Okay, moving on. Yeah, public notice, special meetings. Okay, you have your regular meetings. Maybe they're monthly, maybe they're quarterly or whatever, but something has come up. Maybe there's like a grant application program that the board needs to take action on. That can't wait for the next regularly scheduled meeting. So you want to have a special meeting because you want to deliberate and vote on this matter. So the Sunshine Act allows you to have these special meetings, but now the window goes from 72 hours to 24 hours. Okay, you still need to post the legal notice in that paid newspaper of general circulation. It's just that it only needs to be posted within 24 hours of when you would convene the special meeting. Okay, all the other conditions are the same though. Then you have a provision that allows for emergency meetings. In the event of an emergency where you've got to get the board together to make a decision, you do not have to have any public notice. However, beware of creating your own emergency. Okay, again, straight face test. Given all the conditions that led to the decision to have the emergency meeting, is it in fact a bona fide emergency? Okay, and I am aware of public officials who had to stand up in front of a judge and explain why it was an emergency because a member of the public called him out on it, disagreed, and filed suit at the county level. And unfortunately, there was a recording made of a comment by the chairperson who said, and we're doing this to get out from the Sunshine Act. Okay, so that led to, you know, a touchy situation with the judge. But so don't try to create your own emergency to avoid getting out from under the Sunshine Act. You always get caught, you know, sooner or later the truth comes out. So don't try to outthink these laws. And then if you have to cancel a meeting, like let's say somebody gets sick and you don't have a quorum, there's no requirement within the Sunshine Act that you need to post it, that you need to notify the public that you're canceling the meetings, but do your best to let the public know that you're not having the meeting. Again, here's where your social media tools can really come into play and help out with letting the public. Nothing upsets people more than, you know, there's the expectation that you're going to have a meeting. They, you know, cancel their other plans, come down to the borough hall or the township building or whatever. All the lights are out, the doors are locked, and it's crickets. Okay. Then the next day they found out, well, the meeting was canceled, you know, because we couldn't have a quorum or whatever. Do your best to let the public know. It's good customer service. It's good public service. Okay. But there is no legal requirement. All right. I want to talk about agendas. This goes back a couple years now, but it is a recent change to the Sunshine Act. And it came about because it was felt by several members of the public that boards were sneaking in agenda items at the last second without word getting out to the public that they were going to vote on some controversial issue. For instance, down my way here in central Pennsylvania, we've got a lot of these warehouses, okay? And because of the highway structure, it's just a good area for having logistical warehouses in place. Well, people are getting upset because of all these warehouses. And there need to be zoning changes and the board needs to vote on these. And there were a couple instances where the board wasn't telling anyone that we're going to vote to approve this new warehouse tonight. Okay, so you know, that's just one of many examples where the legislature realized that, yeah, we have a problem here. So they put in this agenda requirement with the Sunshine Act, the most recent change to have taken place. Essentially, and I'll break this down here, all agencies must post an agenda of issues that they're going to be deliberating on or voting on at least 24 hours before the actual public meeting. Okay, and this includes regular and special meetings, not emergency meetings. Okay, now it also doesn't include work sessions. Why? Because there, you know, technically there's no deliberation or voting at work sessions. And it would include executive sessions, and I'll talk about what an executive session here is shortly. The agenda must be posted on the agency website if you have one. And if you're not using a website but are using, for instance, Facebook or Discord or you know, one of the other platforms as your primary social media presence, then you put the agenda there. It also needs to be posted in the agency offices and at the meeting site, okay, 24 hours in advance of the meeting. And then when you have the meeting, you need to have copies of the agenda available to hand out to the public. Again, reinforcing the idea that the legislature expects a physical meeting at these gatherings. Okay, questions have popped up here. Is there any case law on social media pages being websites? No, the fact that we put this in here is our interpretation. Okay, the term website, we believe, is generic in its use. So, and we're finding that there are some small jurisdictions, like, you know, boroughs, townships, or whatever, that aren't willing or able to pay the hosting fees for a website when they can use Facebook for free. So they set up a free Facebook page, and that's how they notify the public what's going on. Okay, so from our perspective, for purposes of the Sunshine Act, that's a website. Okay, we believe that website is, in this instance, being used in a generic sense. When posting on social media, does the agenda itself need to be posted, or does a link in the post to the agenda suffice? Jennifer, I think the link would be adequate because you're meeting the spirit of the Sunshine Act. And as long as the link takes you to a copy of the agenda, I think you're good, okay? Saying posting general agenda on the door with a URL or QR code to access the detailed one, is that okay? Oh my. Yeah, I think if you're posting the agenda on the door, you're good. If it includes the URL, as long as it takes you to a social media outlet that's controlled by the agency, meaning, the borough or the township or the school district, you're okay. The question comes down to how hard is it to find the agenda? Okay, and if it's not hard, if it's just a matter of clicking a link, you should be okay. Yeah, and Walt, you're saying not everyone has access to the internet. That is true, which is why it also needs to be posted at the building and so forth. All right, I don't want to get into the weeds here with these technical questions. And the QR code is a good one. We're seeing more and more use of that. Although if you work in IT security, you're probably shouting at the top of your lungs right now, no, don't use QR codes, but I'm not, that's up to you. But the bottom line is look at the spirit of what you're doing. Is it assisting the public in a convenient way to comply with the provisions of the Sunshine Act? Meaning, can I click on a link? Can I quickly access the agenda without having to, have any special IT knowledge? Okay, then you're okay. Yeah, I understand the issue with the QR code. And more people are using smartphones and the QR code functionality, just like when you walk into a restaurant nowadays. You want to see the menu? Here's the QR code. I understand all that. Okay. But the point was made by Walt earlier. Not everyone has access to the internet. And trust me, I've been called out on this because of that very comment. So you want to make sure that in addition to the website, agency office, meeting sites, and at the meeting itself, then you'll be okay. All right, but if you're using the QR code, that's fine. I think you're good. I think you'll be good with that. All right. Okay, I think we've covered this part of the agenda. Let's go into this a little more. Do attachments have to be available? Let me get into that on the next slide, because I think that's a good point. Okay. Now, changing the agenda, okay, there's a timeline, and it's based on 24 hours. First offhand, prior to 24 hours, anything further than 24 hours before the meeting itself, you're good. You can make whatever changes to the agenda that you deem necessary. Then you come into the 24-hour window. At that point, a hold is put on changes, so that the only thing you can change are emergency issues or what we call de minimis issues, meaning that it doesn't involve a contract or any expenditures. This is based on case law, a recent case, Coleman versus the Parkland School District, where at the meeting they voted by majority to change the agenda so that they could ratify an employee contract. Mr. Coleman, who used to be a board member and is now a state rep, filed suit and won. And the court said, well, I'm getting ahead of myself, but no changes from 24 hours on to the beginning of the meeting that rise above a de minimis level. Then when the meeting starts, okay, there can also be no changes to the agenda unless it's of a de minimis nature, meaning that we're not voting on any contracts, we're not voting to spend any money, and the court has some kind of generalized language in there that if you're going to vote to change the agenda during a meeting, it's got to be for some pretty small stuff, or again, a bona fide emergency that comes up. Now, what if during the meeting you do decide to change the agenda? It must be done by majority vote, okay? And this all has to do with the official record of the meeting itself. Something comes up, okay? So the board wants to act on it, and it's just a small issue that, you know, it meets the definition of de minimis. So the board, number one, there needs to be a motion. You know, I move we modify the agenda to include this issue. Okay, so then you go through that, your Robert's rules or whatever. You have the motion, you have the second, you have discussion, then you have the vote. And by the way, you may have to open it up to public comment depending on things. Then you need to announce to the public why you're doing this. That needs to be stated to everyone present at the meeting. Then you can add this to the agenda and have whatever deliberation you want to have. If that leads to a vote, good, okay, it becomes part of the official record. Maybe it just results in discussion and you decide not to vote. That's okay too. But because you're having deliberation, you need to, number one, amend the agenda by vote, and then you would have the potential for a vote on whatever it is you're now discussing as the issue that was added to the agenda. And if you do have a vote, then that gets memorialized in the minutes of the meeting, which should last forever, okay? It's the gift that keeps on giving. Now, you have an amended agenda. Okay, once the meeting has concluded, within 24 hours, you need to post the amended agenda on your website, Facebook page, social media presence, at the meeting site, and within the business office. Okay, the question comes up, how long does it need to be posted? I don't know. Okay, there's nothing in the law that says how long it needs to be posted. But here's George's recommendation, okay? And I have no authority, but I've noticed a pattern of 24 hours. 24 hours before the meeting, 24 hours after the meeting. So by logical extension, which may be wrong if it ever gets litigated, the judge may ask, who's George? And George is nobody. But I would say if you post it for at least 24 hours, you'll be okay. All right, that's just where we're at now. I may be proven wrong someday, but that's what I would do if I were in your shoes. Okay, and like I said, the minutes, which are the official record of the meeting, must reflect any changes to the agenda. Okay, so that I can go back years from now and say, okay, this is how we got to where we are by looking at the fact that the board added this to their agenda and deliberated about it. And this is, you know, what occurred. All right, hopefully that makes sense. Now, to get back to the question about attachments, the question comes up routinely. How detailed do our agendas need to be? I use the reasonable citizen rule, okay, which in fact is not a rule itself, it's just a perspective. If looking at your agenda, a reasonable citizen can figure out what it is you're going to be discussing and voting tonight and have a clear idea, a reasonably clear idea as to what it is, then I think you'll be okay. But if your agenda has a tendency to talk in code or use acronyms and buzzwords that me as a citizen have no idea what it is you're going to be discussing and talking about, for instance, rather than saying, we're going to be approving the request to build a warehouse on this road. It says we're going to be discussing I don't know, proposal number 508B on plot number 566C, provided by the QSC Corporation, that doesn't tell me anything. All right, so put it in English, write out a paragraph or two that explains to the public what it is we're going to be doing. As far as as far as attachments go, if the attachments can provide that light, can provide that clarity, then I would recommend yes. There's nothing, attachments aren't mentioned in the Sunshine Act, but you have to take a global view. Okay, yeah, walls. Yeah, you're reading my mind. I've done this in the past. There is a standard that I've referenced in the Reading Eagle case, which we'll talk about when it comes to executive sessions. I might as well talk about it right now. With executive sessions, this Reading Eagle case says, what would a reasonable person expect to understand based on what they're being told about what a board is doing in a private session, okay? Is it enough that a reasonable person can trust the board to be doing the right thing? Okay, so I apply that standard to agendas. Are you providing me with enough information that I can trust the board is doing the right thing, that I know what they're up to, okay? That we've removed that curtain of privacy so that I understand what the board is up to and I can trust that they're doing the right thing, okay? Again, all very subjective, but in the Reading Eagle case, they reduce it to writing in its discussion of the opinion, okay? So let's move on and talk about some other aspects here of the Sunshine Act. Public comment, okay? There is the expectation that the public has a right to comment on any decisions a board is going to make before they make those decisions. If we read the act itself, it said commenters can be limited to residents and taxpayers, okay? So if you have someone from out of town who signs up for public comment, you can say, no, we're not going to allow that. This is local government. Only people within our jurisdiction are allowed to comment. You can allow them if you want, but you can also not allow them. Okay, then the law says people have a right to comment. Actually, residents and taxpayers have a right to comment on issues that are or may be before the board. Okay, that word may is somewhat problematic because we go back to another law called the Statutory Construction Act, where may also means may not. Okay, but because it's in there, you've got the issues on the agenda. Then you've got Joe Q. Citizen who wants to stand up and complain about the potholes on his street, which are not on the agenda. Well, because that word may is in there, he's allowed to do that. Okay, he can stand up, point a finger at the board, and address it on whatever is on his mind. Okay, now that's problematic, but let's work this through. The board can establish reasonable rules for public comment. The most common one are time limits. Okay, we're going to give everybody 3 minutes tonight to talk about, and it may be part of the memorialized rules that become part of the code for that particular borough or township or school district. But if they're just rules for conducting a meeting, if you follow Robert's rules, there's a provision in there where you can set the rules aside. So maybe tonight we want to change it from 3 minutes to 5 minutes, okay? Make a motion, set the rules aside. We're going to change it to 10 minutes, okay, or 5 minutes, okay, problem solved. You can do that. So then we get into the idea of this word may and how we don't want someone standing up in the middle of our discussion about warehouses and complaining about potholes. Well, what some jurisdictions have done is establish 2 comment periods. The first one deals solely with the issue at hand, okay? This is what we're talking about. We're talking about the warehouse. So we're going to restrict all public comment to the warehouse. Then at the end of the night, as part of the agenda, we're going to have the second general comment period, where if you want to stand up and complain about potholes, that's your time for doing it. Okay? And that seems to work. Now, there is nothing in the Sunshine Act that says this is what you have to do. It's simply a best practice that was brought to our attention by a number of jurisdictions, local governments, and it works for them. Okay? All we're saying is maybe give it some thought. When meeting rules are changed, they have to permit public comment on the meeting. Argue that, you know, if you're going to suspend the rules for the night, in this particular instance, that's because it's administrative in nature. It doesn't rise to the level of a decision as far as, you know, my interpretation would be concerned. Okay, so, you know, as part of the reasonable rules, maybe you want to have 2 comment periods, but there's nothing requiring that you do it. We're just saying that as long as it's reasonable, meets the spirit of the Sunshine Act, you might want to give it a thought. Okay, executive sessions, here we are. An executive session is a gathering of the board outside of the public eye due to some sensitive issue that they need to discuss where, you know, they don't want to jeopardize confidentiality in any way. So executive sessions can be held before, during, or after an open meeting, or they can publicly announce, tomorrow night we're going to have an executive session. And then you need to provide the complete reason for announcing why you're going to have the executive session. And you need to announce that during the open meeting. And we mentioned the Reading Eagle case. Okay, what was happening in the city of Reading? The chairperson would stand up and announce, we're going into executive session for personnel rules. The Reading Eagle, which is the local newspaper, disagreed. They said, that's not enough. You need to tell us more. And they filed suit in the Berks County Court. The court agreed, and it ended up being appealed all the way up to the Pennsylvania Commonwealth Court. And in the language that they put into their decision in favor of the Reading Eagle was something to the effect of, and I think it, you know, they were actually quoting the Tennessee Supreme Court, where in essence, they were saying, look, when you meet behind closed doors, at that point, you are violating the trust of the public because you're no longer deliberating in the light of day. So in order to regain that trust, you need to tell the public enough as to why you're meeting behind closed doors so that they're now satisfied and you've regained that trust. Okay, again, all very subjective, but rather than saying just for personnel reasons, you would say something to the effect, for example, we need to discuss a potential violation of work rules where we may have to suspend an employee. Okay, that tells me that number one, it is serious, and it tells me why you can't discuss it in public, because for fear of potentially embarrassing an employee who may not have violated the work rules, okay? Or, for instance, we need to meet for legal reasons, but it's related to this case, which has been filed in Common Pleas Court by so-and-so who's alleging that the city violated their due process rights or something like that, okay? So, and maybe provide the case citation so that, yeah, you can't discuss legal issues in public, okay? But you're telling me what the legal issue is. And in fact, you're even telling me what the case is, okay? So that, yeah, now I know you're going into secret session, executive session for a valid reason, okay? You've regained my trust, okay? So I don't have a problem with it. Do personal executive sessions pertain to interviewing public employees? It depends, Matt. There are some codes, for instance, like with school districts, that would require interviews to be done in public. There are others that do not. Okay, when it comes to actually, you're ahead of me by one slide. Okay, And I'll get to that. Okay, now for executive sessions, there's no requirement for minutes, but if you do keep minutes, the right to know law exempts them. No official action can be taken during executive session. You can poll members to see how they're leaning, which way they're going to vote, but the official vote, you basically conclude the executive session, then you reconvene the public session, and that's when you need to take your vote, where, for instance, we're going to suspend this employee for 3 business days, okay? And, it needs to be an actual vote that occurs in a public setting and needs to be memorialized in the minutes of the public meeting to be considered official action. Okay, some questions have popped up here. Yeah, Matt, I'm going to cover you in the next slide. Butler versus Indian Lake Borough provides even more detail on that. Yeah, another good decision. Can a person that was in an executive session discuss what was said in that meeting in public? Yeah, well, they can, but they may be subject to some form of sanction by the rest of the board if they deem that's what they need to do. Okay, and this occurs. Sometimes, maybe it's a political issue, meaning big P with parties, and you've got someone in the minority who decides, well, I'm going to go spill the beans on what we talked about. And the board, this is not in the Sunshine Act, but the board can take whatever action it deems is legal and is necessary to deal with that. Okay. But it's not in the Sunshine Act itself. And this occurs periodically. Okay, so let's move on to the reasons for why you can go into executive session. Personnel matters. Matt, it is the personnel matters that relate to individual employees in individual positions. If you're discussing, for instance, interview policy, that would not constitute a valid reason for going into executive session. Now, for interviewing, most interviews you can do privately, okay? There are some codes that require that once you reach a certain level, like the final 2 candidates, that has to occur in public, but that's going to be determined by the code, not the Sunshine Act or any case law related to the Sunshine Act. And really, I think it comes down to school districts are the only ones that really need to worry about that. And I am not intimately up on the Pennsylvania Public School Code to give you a definitive answer there. I'm going to say it depends, but in most cases, to answer your question, it's no. All right. So personnel matters, hiring, firing, discipline, and the like. Discussing labor negotiations, yeah, that makes sense. Why would we divulge our negotiating strategy in a public meeting? Considering the purchasing, leasing, or selling of property. Okay, the law itself does not say selling, but there is an unpublished Commonwealth Court decision where they said, look, if you're going to sell property, you could put yourself at a disadvantage for property values and in negotiating by revealing certain details about what you're selling. So you can discuss selling public property in an executive session. Consulting with counsel about litigation, avoiding violating privilege or confidentiality. Okay, here we're talking about attorney-client privilege. Discussing the university admission standards. Like I said, this was written in the 1950s, so I'm not sure why, but discussing emergency preparedness. This is a more recent edition, I think probably about 10 or 15 years old, but it deals with Homeland Security, where if you are discussing issues related to emergency preparedness, you can do that in executive session. Discussing a contract with an organization that the agency is working with, like negotiating a contract. Typically, negotiations like that could be conducted in an executive session or a private session. I think you would need to look at the provision about violating privilege or confidentiality. And you really, again, it goes back to looking at what is the intent of the Sunshine Act? Why are you meeting in private? And is it in the spirit of the Sunshine Act and government transparency? Negotiating a contract, I think you'd be okay. Okay, if an agenda says, for example, to request approved collective bargaining agreement, is that sufficient? Would that be the full? Okay, Patricia, that's going to be on a case-by-case basis. Certain agencies, you're talking about the agenda, how detailed do you need to be? Certain codes require that the proposed contract be available for public scrutiny for X number of days before it's actually voted on. All right. Then there are others where there is no requirement. And here, I think we're talking about primarily when there's and again, I'm not up on the public school code, and I'm not sure this is in fact is a provision, but I know that proposals have been made. That's why I'm kind of unclear on my thinking here. But it may be that for public school collective bargaining agreements, there needs to be a review period before it's voted on. But I'm not sure of that. Okay. So just putting that we're going to vote on the collective bargaining agreement would be acceptable. There may be others where it's a requirement that that agreement be posted for X number of days before it's voted on by the board. And given the Parkland decision, the union ratified it that afternoon. So the board decided they were going to approve the contract that night, which makes me think maybe there wasn't a posting requirement. But I don't know. I want to be very careful in what I'm telling you. And the bottom line is I don't know for sure. But I know that there are instances where it's required that a contract be posted, a proposed contract be posted for X number of days before it's ratified. I would have to look into that further to give you a definitive answer. I just don't know at this point. I apologize. Okay. So those are the reasons for having an executive session. Let's get into violations. We're approaching the end of the presentation here, but during a public meeting, a member of the public can object at any time to a perceived violation, meaning I can stand up and say, excuse me, but I think you're violating the Sunshine Act. At that point, you've met you've done what you need to do. Okay, you can sit down respectfully, and you are not out of order by doing that. Okay, just don't get obnoxious about it. Just say, I think, by not voting right now, or by taking a vote without allowing public comment or whatever, I think you violated the Sunshine Act. Okay, you had your piece, you've had your say. So you sit down. Now, if the board agrees with you, you say, you know what, you're right, we forgot public comment. Okay, we're going to go back and allow public comment now and take another vote. The board, in essence, is curing the violation. Okay, they are allowed to do that, no harm, no foul. Okay, so they can go back and make things right. It doesn't even have to occur during the same meeting. They can do it at the next meeting, given how things may have proceeded. All right, but what if they disagree? What if they say, no, we think you're wrong. We're in adherence to the act, and we're going to proceed as we originally intended. But you still disagree. Well, within 30 days of the perceived violation, you can go to, if it's a local agency, you go to your common pleas court in the county. If it's a state agency, you go to the Pennsylvania Commonwealth Court and you file for relief, legal relief. And that varies from county to county on how it's administered, and it depends on what you want. But usually what will happen is you file suit, the judge will usually call a hearing and hear the parties out. Now, this doesn't happen a lot, but we're seeing it happen more and more. People are getting more active with filing suit against agencies based on perceived violations of the Sunshine Act. And judges are getting more and more familiar with the Sunshine Act and how they view the whole issue. And judges have a pretty wide leeway in what they can do if they believe a violation has occurred. They can say, yes, it's a violation, just don't do it again. Slap on the wrist. Or they can say, it's a violation, you need to redo this vote in order for it to be in compliance. Or they can say, I'm going to void the whole meeting. And I've seen that happen. There was a case 2 years ago, maybe 3 years ago now, up in the Scranton area, where they voided an entire meeting. They said, no, you did this wrong. Go back and do it again. In particularly egregious cases, the judges have levied fines against officials. For the first violation, it can be up to $1,000. For the second violation, $2,000. The fines are paid by the public officials, not the agency. The agency cannot pay the fine on behalf of the violator. So it gets, I talk about the straight face test. It gets kind of painful if you try and pull a fast one or play, fast and loose with the Sunshine Act and you get caught, okay? Now, it doesn't happen a lot, I should say that, but we do have a record of this occurring periodically. And like I said, you catch a county judge on a bad day, it can get painful. All right, moving on. And just some miscellaneous stuff for the good of the order. You must produce meeting minutes recording board attendance and who voted for and against. Okay, this is in addition to what you will find about meeting minutes in the appropriate code for your borough, township, or school district. Okay, this is what the Sunshine Act says. You got to have minutes. It has to record who was there and who voted. And if it's a roll call vote, then it needs to record how each individual member voted. The public can record meetings and they can do it unannounced. It's not a violation of the Sunshine Act and it's not a violation of the Pennsylvania wiretap laws. Gosh, I think 2 weeks ago, just 2 weeks ago, I saw a news story where, the board said you're not allowed to record our meetings without telling us. Well, guess what? You are, okay? I can, for instance, put my smartphone on record, put it in my pocket, walk into my public meeting and not tell anybody. And I can do that. Usually, it's a good idea for the chairperson to announce at the beginning of the meeting, there is no expectation of privacy. This meeting may be recorded and, any comments you make might be a matter or will be a matter of public record. Okay. If the agency itself is recording the meeting, those recordings are a public record and discoverable under the right to know law. Okay, do the meeting minutes have to reflect the announcement of an executive session? I don't know that for sure, but I'm gonna say probably. Okay, the fact that there was the executive session doesn't need to have minutes, but the fact that there was an executive session, I think it does, okay? And usually what I've seen lately is that executive sessions are being included on the agendas for public meetings. Okay, so I would think, there needs to be some memorialization that the executive session did in fact take place. So I think the logical place for that to be, especially since executive sessions need to be announced in a public meeting, and pardon me for thinking out loud here, executive sessions need to be announced in a public meeting along with the reason for the executive session. So the mere fact that the announcement is taking place, in my mind, indicates that it needs to be memorialized in the meeting minutes. So I'm going to go out on a limb here and say yes. Okay, but again, I'm not aware of any case law that backs that up. Okay, so I'm not providing you with a legal opinion. I'm just kind of thinking out loud here and saying, I would do it. Okay, so the recordings that are taken by any agency of their own public meeting, that recording is a public record until it is destroyed. Okay? Yeah, here we are at the end, okay, of a very good session. Thank you for all your questions. If you have any more, now's the time to get them in before we close up for the day. But, I mentioned a couple times about our website. It is a tremendous resource that I would suggest you take a look at. There is a page on the website specifically for the Sunshine Act, along with FAQs. So that might fill in some of the blanks with some of your questions. Regarding the right to know law, you're going to find a number of guides there that, again, will prove helpful. But, take a look at the website. If you have any questions, reach out to our office. That includes the Sunshine Act as well. A lot of times those questions get forwarded to me, and I'm more than happy to answer them and provide insight. There are attorneys on staff who are also up to speed on the Sunshine Act who can help you out. But again, I want to thank you for your participation here this morning, and we'll be back in 2 weeks with our next webinar, and we hope to see you then. Okay, folks, take care, enjoy the weather, and yeah, thank you, and we'll hopefully see you then. Signing off now.